Commissioner?
Yeah, so do I continue waiting or?
Yeah, has it said that the meeting is starting in a few minutes?
Just now, 2 minutes.
Because, just hold on, because it's not saying that.
Yeah.
Because I'm still getting in and then it's still telling me the same thing that.
Don't worry, just now.
Okay, yeah, it's just starting right now.
We are broadcasting.
Yeah, it's broadcasting now.
Yeah, 1, 2, 3.
Join.
You're done? Okay. We can see you.
Okay. Do we start?
Yeah, just give us a minute for people to join in.
Okay. I think Mashari is facing a challenge.
Okay. Thanks for joining us. I see we already have about 63 people who've joined in.
Oh, okay.
So we'll give you a few minutes to just join in. Apologies that we are running a little late. I'll just give it a few minutes to just have everyone come in. I have 108 people who've already joined in. So just give us a few minutes, right?
That's fine. Yeah. That's fine.
Yeah, this is gonna be exciting. Okay. If you're joining us, we're just giving it a few minutes, maybe another 5 minutes to just begin. Thanks for joining us today. This is an event by ICJ, the International Commission for Jurists. And we promise to have some really interesting discussions in a few minutes. And so I would like to, allow, do I have the Executive Director speak? Okay. If you can hear us, just type on the chat if you can hear us. And if you need to ask a question, you can raise your hand. There's a feature that you can use to raise your hand and join us. We have, I think, 137 people who joined us. Thank you so much for joining us today.
Thank you.
And so we're just going to begin in a few. First is just housekeeping. If you need to ask a question, we have a chat. I would really love your feedback. Thank you so much. You can hear us. Thanks, Leon, Gishana, Albert. There's so many of you, Sylvia, Anna, and Johi. Thank you. Thank you for joining us. And so I'd want to just have my colleague from ICJ make a few remarks before we begin.
Yes, thank you very much, everyone, for finding time to be here with us. My name is Silas Kamanza, and I'm a program officer at ICJ Kenya. I'm really happy to be here, and I'm really happy that all of you have been able to be with us today. I hope that we'll have very good deliberations as we go on. I know that it is quite a tough subject, but we have an extraordinary panel. We have extraordinary panelists today with us who will share with us their experiences and their views and recommendations on legal practice during this COVID-19 pandemic. I hope that we are going to have a very active deliberation. Please do not hesitate to contribute on our social media at ICJ Kenya on Twitter and at Lawyers Hub on Twitter and Facebook. We hope to have a series of conversations and to provide a platform for lawyers and jurists across, not only in Kenya, but across the East African region, so that we can deliberate very pertinent issues regarding our legal practice during this period. Thank you very much for finding this time. Perhaps maybe I can find out if all our panelists have been able to join in.
Yeah, I just added Maria, and also we have Commissioner Macharia Njeru,
yeah, that's good.
who's going to join us just in a few. Please help me with I'm just trying to get this. Okay. Commissioner, if you can hear us. Okay. Commissioner Macharia, can you hear us? You can unmute your mic. I just unmuted you. Maria Beneka, can you hear us?
Yes, I can hear you.
Okay.
Hi, Linda. Hi, Silas.
Hello. Hi, Linda. Hi, Maria.
Okay. Thanks so much. I would love a program to get our other panelists going. So I just wanted to do to contextualize this particular discussion. We are all coming to terms with the pandemic, and we have several issues that are rising, from access to justice, to the use of technology, to figuring out how lawyers are going to, stretch a little bit of the pie so that they can enjoy, still benefits to their firms, still be able to give public service to those who need, legal aid in these times. And so ICJ saw it fit to organize this particular event. I'm personally a member of the ICJ, and the International Commission of Jurists does an amazing job. I'm going to ask my fellow moderator to just talk about what ICJ does and why we're doing this today.
Thank you so much, Linda. ICJ Kenya is is actually the oldest human rights organization in Kenya, having been established in 1959 and registered under the Societies Act in 1974. Okay. So we've been here for quite a while, working on issues of human rights, democracy, and the rule of law. We have worked very, very closely with the government, other civil society actors, and the public to ensure that these issues have been, to ensure that human rights, democracy, and the rule of law is respected, and that international standards are observed during even election periods and in the governance of our different issues and at different levels, including the county government, the national government, and regarding other issues, including mining, etc. So ICJ Kenya has for a long time worked together with the judiciary. We've worked together with the executive and the legislature. We have a very, very close relationship with the public, because we ensure that we link the levels of policy and policy reforms and research, and we ensure that this actually reaches the grassroots level. Perhaps with that, maybe as we continue, I can see that one of the panelists, Patrick Kunjiri, is online, and Christine as well. I could give them a minute to basically introduce themselves in one sentence or two about what they do, and just introduce themselves. Thank you so much. And is Maria there?
We'll start with Maria. Maria, please introduce yourself.
Good afternoon, everybody. My name is Maria Mbeneka. I am a council member of the Commonwealth Lawyers Association. I am also a member of the Lawyers Hub and the ICJ. I'm happy to be here, and thanks for inviting me as a panelist.
Okay. Thanks, Maria. How are you coping with COVID? What are you doing?
Balancing is quite tricky. I mean, you're at home, so you're more tempted to do stuff around the house. So it requires a lot of discipline. You have to get up, dress up like you're actually going to work so that you can get into the work mode. I find that's what's helping me quite a bit. Okay. But adjusting to our new normal, it's not easy. And well, we're making the most of it as a firm, okay, and myself as an individual with the family setting.
Okay, thanks for that. We'll go to Macharia, Commissioner Macharia Njeru. If you could speak. I've tried to unmute him, but all right. Commissioner.
You can hear me now?
Yes, we can hear you. I wish we had your video. We don't understand, even if there are pets running around or children, it's okay.
Okay, all right. Thank you so much. Now, for me, it's...
Thank you.
You can see me?
Yes, we can see you.
All right, wonderful. Thank you so much for inviting me as a panelist. It's quite exciting. I'm also a member of the ICJ.
No, the ones that are in a box. What are
and just like Maria said, it's a very challenging time for all of us.
Yeah.
But thankfully, it is not just us in Kenya, it's a world thing. I guess it's also a lesson learned for all of us that sometimes human beings, I think we need some surprise for us to be able to realize that we are not that powerful. Because if a small virus can bring the whole world to a standstill, that is quite telling. But having said that, human beings always have a way of being able to see themselves through challenges. This is not the first time the world has faced a challenge. And I am quite confident she'll be able to go through this one. In our law firm, we decided that we continue functioning as much as possible, because one thing that I'm conscious about is the fact that we would want to see a situation whereby we're able to support not only our clients, but also our staff. In fact, the position we've taken as a law firm is if we can ensure as much as it's reasonably practical that our staff don't go without a salary or even without any salary cut, we'll try to achieve that as much as possible. That means also maintaining some reasonable measure of operations. And therefore, we are trying to use the ICT, and wherever possible, we're also coming to the office and observing health guidelines, but also making sure that we stay safe. I think that's opening remarks.
Thanks so much, Commissioner. I'll invite Patrick to introduce himself. Patrick, if you could unmute your mic. Yes. We can't hear you. You have to unmute your mic. Okay. Okay. So let me see if I can fix that. Meanwhile, I can just have Christine as we sort out Patrick. Okay. Christine, you could introduce yourself.
Hi, Linda and Silas. Can you hear me?
Yes, we can hear you.
Okay. You can. I don't know whether you can see me also.
No, we can't.
I don't know why the video is off now.
Yeah.
Okay. Let me just say hi as I figure out how to get my video working.
Okay.
So my name is Christine Konge. I work with the Katiba Institute. Katiba Institute is a research and litigation organization dealing with quite a lot of things around ensuring the rule of law and constitutionalism in Kenya. We have been heavily involved in litigating, try and change. There's an echo. Can you hear me?
Yeah, you're logging in from two devices. So if you could just log out of one device. Okay.
All right, let me see.
Yeah, now we can hear you perfectly.
Okay. So yeah, we work around entrenching constitutionalism in Kenya. And just what Macharia has said, we are also trying to adapt our systems. So we've also been challenged in a positive way by COVID, because now we are more conscious in ensuring we are more tech savvy as an organization. And I think this will be a good change, positive change that comes from this COVID, because we are also now just updating our systems to make sure we are fully capable of working and remotely.
Okay. Yeah. Right. Okay. Thanks, Christine. I'll go to Patrick. Patrick, now you can hear. We can hear you now. Thanks.
You can hear me now?
Yes.
Good morning, all of you. My name is Patrick Ngunjiri. I am presently the Vice Chair of ICJ Kenya. Besides that, I am a practitioner. I'm amazed because we are living at a very, very difficult, unprecedented times, just like everybody else has said. I have practiced law for 19 years, but I have never had to close the law firm for this long, except during December. So we are all learning. We are having to put in measures to ensure that we are serving our clients. But as we shall discuss during this session, I think our practices are like limited because they are predicated on what happens in court, what happens in the court registries and what happens in other players like Kipi and all those things. So we have had to innovate, working from home, creating workstations from home, ensuring that staff are ready. And where we need to serve our clients, we have been able to send documentation to clients by email. So we are leveraging on technology. So I look forward to having very fruitful discussion. And I also bring greetings of ICJ Kenya Chair Kevin Mugeni, the council, the ED, and the entire secretariat, and the entire ICJ family. We look forward to having very fruitful discussions this afternoon.
Okay. Thank you so much, Patrick. Now we would want to go into the panel discussion. If we could first have different views from the speakers, and I'd want to start with Christine. From just comparing the work that you're doing at Katiba Institute and vis-a-vis what's happening now with the pandemic, we are wondering what are the short-term measures and the long-term measures that we can employ to ensure that we still have, access to justice for, sorry. Okay. So Christine, can you hear me?
Yeah, I can hear you very clearly, Linda.
All right then. So yeah, our question is, what short-term measures can we take and long-term measures can we take to just mitigate what the pandemic has brought with us, so that we do not have, limitations on access to justice?
Right. Thank you, Linda. For some reason, I can't figure out how to turn on my video. That should show you that this is going to be a great learning period for myself too.
Okay, you have a virtual background. That's what's preventing you from having this. But yeah, we can just do the audio as we figure that out.
Okay.
Yeah.
So yeah, as Katiba Institute, as I indicated, one of our critical things we do in a day-to-day basis is actually going to court on various issues around constitutionalism, a rule of law, and democracy. So basically, we are looking at, if you look at the kind of things that need to happen in terms of all the measures that are being taken by the government to deal with COVID, that whatever measures are taken, they have to ensure rule of law, democracy, and human rights protection, right? So it also means functioning of parliament, functioning of devolution, and functioning of all the arms of government. By rule of course, is that the laws must be followed, and human rights protection, of course, is very clear coming from some of the things that have happened. In terms of human rights, of course, it's very clearly that some of the rights that have been implicated, it has been, freedom of movement. You can't move as you'd want to. There's issues about association, expression, assembly, and even some issues to do with liberty in case of people who are quarantined, because of this COVID. So all of this has a lot of implications in terms of access to justice. Access to justice for people who are in quarantine and might want to get some things done. Access to justice in terms of other critical cases, especially criminal cases, and the fact that those cases are not going on as they should have, and there's the right to have a speedy trial, of course. So there's quite a number of things that have to be taken into consideration. So we have to look at all the sectors of our criminal system, of our justice system, not only criminal cases, civil cases, and the human rights and constitutional cases. All of them have to be taken into consideration in terms of access to justice. So of course, we've been having some hits and misses since the crisis started. I think the judiciary shut down after the very first case was announced on 9th of March, I believe. And then thereafter there's been a bunch of regulations and practice notices that have come out indicating how people should go on to process the cases. Initially, there was some confusion about how to process criminal cases for people arrested, just because of the constitutional requirement they should be in court within the 24 hours. I think as early yesterday, so a couple of days ago, I saw now some new directions that they should be brought to court within the 24 hours, irrespective of what else happens. So the idea then is, how do you ensure the justice system works, but still protect the staff? I mean, the judicial, the judges, the magistrate, and the supporting staff, and the litigants themselves that come to court, and even the lawyers themselves that come to court. So how do you ensure this happens? So that's the big question. And there have been some rules around that. And I think they've seen something from Nakuru recently that now shows they are going to have full automation of the litigation process to allow for that sort of protection of everyone involved, but also to ensure access to justice happens.
Okay.
Yeah. So,
I was just going to chime in and ask.
Yes.
I think yesterday on social media, there's been cases around, what used to talk about freedom of movement. We had this musician, Ekodida, who was arrested for going out to, buying medicine for his wife. And I think that's making, the rounds. I don't know how far that has gone this morning. But how can institutions such as yourself, come in and mitigate such, violations of citizens' rights? How do you help in this case?
Yeah, so that's the thing. Within every rule, there should be some reasonable exceptions to deal with reasonable things that would occur. So we don't actually need to, for Law Society of Kenya to go to court to be able to provide for some reasonable exceptions to a quarantine situation. Yeah, so if you need to go out, like your baby has a fever, you can't wait until 5 a.m. to go and get some medicine. You need to actually go out and try to get some medicine, whether you go to a hospital or not. The thing is that it is reasonable that should happen. So in every rule, there should be some measures to allow for discretion to be exercised. And that discretion should be exercised in a way that is reasonable. And so that the idea then is whether the police are properly briefed to be able to understand what are the situations that would allow for the discretion to be exercised in a way to allow citizens to access urgent medical care and other things, even during COVID.
I think with the police, and I think Commissioner Macharia, from having been at IPOA, would be able to comment on this. People are complaining the police are having a field day, and we are treating isolation and like detention centers. We're taking people to these centers, but it looks like it's detention that you pay for. How do we stop this? And that's my first question to you. And number two, what do we sue about? What areas? Because the Law Society went to court. There are some quarters who thought that we shouldn't be suing about curfews, but maybe we would focus on broader issues like access to internet, now that people are at home. We could be talking about freedom of movement, that would touch on specific sectors of society for people who are elderly or sick, people who need to go for dialysis. What exactly should we prioritize in strategic litigation at this particular point?
Well, okay, as with everything, strategic litigation looks at the most pressing need there is at that particular time. And so it's very difficult with this situation because it's very fluid. Things keep on morphing, things, new issues arise as the situation unfolds. So I think if you've been able to see the advisory we gave together with Kelly and quite a number of other civil society organizations, we put areas that different areas that should be looked at and give advice on what we think the measures are. So of course there are issues to do with quarantine. I think that is quite a critical thing to happen right now, especially when I disagree with the government by saying this is a voluntary agreement you are getting into with the hotels and everything. So the questions around what should happen when you're not able to pay for this facility and you have actually been forced to quarantine against your own wishes. This is done for a greater good, but then the government should be able to ameliorate such conditions. I saw somewhere somebody and his wife both had a bill of 90,000 shillings for 14 days in a government facility. So that's 180,000 for a family that you hadn't planned for. So there should be those issues around the quarantine procedures, how they are being applied. I find it quite interesting that the government keeps on extending quarantines for some facilities because people supposedly did not follow the rules. I find it very interesting that the government, within such a contained situation, is still not able to ensure rules are followed and keep on adding to the burden of Kenyans to economically continue to cater for their own quarantine when other people are not respecting the rules and some are. So they are those issues around quarantine I feel are very urgent. There's also issues to do with the effects of the lockdown measures on the socioeconomic, status of people who, for the lack of a better word, I would say the gig economy, the people who have to actually, the informal laborers who have to go out every day to get work so that they can be able to have a meal. So there is there needs to be a litigation around what strong measures are being taken around that. I know the government has said they have identified. We don't know how this was done. We don't know the measures they have put, the processes that were used, who was involved. Again, even in this situation, our sharing of information is quite critical. We need to know everything. So the government is getting a lot of money for this. We need to know how this is being done and how the consultations are working so that we can ensure actually the people who require this assistance actually get it.
Okay.
With procurement of medicines, I've been hearing issues around now because the pharmacy, the board, the drugs and pharmacy board is the one that is supposed to procure medicines around for COVID. How is it happening? What's the procurement procedures looking like? Are people setting up shell companies to come and take advantage of this situation? This is where openness and information is very critical. Like, who is this that has been identified to buy medicines around COVID?
Okay. Thanks, Christine, for that. I really appreciate. I want to just have Maria join us. There are questions that we have had around practice. Yesterday, the lawyers have released a survey on, how, sort of law firms are coping with the crisis. And we found that we asked, a particular demographic, and they said that 25% of them are able to pay their staff in the month of May. 75% are not able to pay their staff in the month of May. And so the options they have available include sending people on unpaid leave. Some of them are looking for loans from banks. Some of them are, having, chasing clients to pay. And some of the clients are not paying right now because, there's difficulty everywhere. So how do law firms stay afloat? One, how do lawyers reinvent? And now that everybody is online, how do we reinvent? And how does our judicial system respond to this particular pandemic? I'll mute you, Maria. Yeah.
Okay. Yeah. Thanks, Linda. It's quite tough for law firms across the board. Any of the law firms, whether large or small, are having to adjust quite significantly. And the question about how to stay afloat and reinventing. Let me just start from staying afloat. Now, most practitioners do not look at their law firms as businesses. It's never been quite, a priority for many law firms. So if for example, you're a law firm that has actually projected on your financials for the year, then it will be easy for you to adjust. But if you've not done it as a practice in terms of planning for the year and your revenue sources, then it becomes that much more difficult to stay afloat. So the first thing about sending staff on unpaid leave, that's an option, and I've seen it's been discussed in Sakaja's bill that I hope members are getting so that they can give their views and their feedback. But interestingly, it's the bill provides that you cannot sack an employee, but get into an agreement where they will go on unpaid leave, which then begs the question: what happens after the work resumes? And if this is maybe after 3, 4, 5, 6 months, what happens? Do you then pay for the months that you are not able to pay, and how will it be done? Where will the money come from? So there's a question there that needs to be addressed, because you cannot give what you don't have. So for me, I think it's important for us to be alive to the fact that employers are also struggling as much as the employees, because their revenue sources are also affected. We have this discussion about reinventing. So I'll go back to the business development, business planning. It's very important to have a sound business plan for your law firm. And it's important for this to become a culture for the law firms and any type of law firm, whether you're a sole practitioner or a small, mid-sized to large firm, so that this is a conversation you're having in your monthly meetings, in your monthly forecasts or review, and with your auditors and your accountants, so that then you look at how have you positioned yourself. Are you specializing, for example, so that you know where your money is coming from? I find that in our discussions that we've had with many lawyers and many law firms, this has not been something that lawyers have focused on. And it is my hope that now we will be able to do so with the emerging law firms. It's a conversation we are continuously having with firms about being ability to forecast and plan the firm for the year, or quarterly or half yearly. So that's important. The second thing about reinventing is, has the firm digitized? So it's important for us to accept that, if you were admitted like me in 2003, we kept physical files for a very long time. I know many of my colleagues and friends still use physical files, but there's an opportunity now that needs to be seized. The younger lawyers who are getting admitted have, laptops straight from, uni. So it's easier for them to have digital records and a digital law firm. So it's important for us to digitize immediately. And if you haven't, take advantage of this time to do so. But then go back to the question, what about those who actually cannot afford to do it? What is the society doing to cushion its members and get into an arrangement with service providers where we can actually get access to digital solutions and farm management solutions that are negotiated by the LSK, for example, so that you can make it easier for us to transition? Because I am of the view that this is a point of no return. We have actually been forced and thrust into the situation where we have to adopt technology in the legal profession. The time has come where we should stop asking who moved my cheese and actually get to the program, because this is not going to go backwards. If you look at the judiciary, for example, they have already gazetted the practice directions on e-filing, service. If you look at the concerns that are raised by the various presidents of the KMJ or the other judiciary staff about not interfacing with the advocates or members of the public, then it will show you that the direction that the judiciary is taking, funds, being available, and Macharia can comment on this, is that, more and more they will adopt technology and roll it out. So what are we doing as law firms to, capitalize on this? And for me, what I'd say is, let's not miss the opportunity. Let us sit down and evaluate, what is my law firm doing, or what can my law firm do that the other firms are not doing? Law firms now, if you're operating as a business, then you have to ask yourself, am I looking at efficiency? And with efficiency comes the adoption of technology or some automation of sorts. Is this cost effective? And that's why I talked about an organization that we belong to, such as LSK, finding solutions where we can actually plug in and get these services easily. Finding real solutions within the legal marketplace. So are we jacks of all trade, or are we specializing? There are new areas of practice.
I'd want to just chime in there and say, from everyone's view, for a long time, lawyers have been regarded that if you don't go to court, then you are actually not a practitioner. And so we have a lot of lawyers stuck in commercial law, litigation, and not looking at new areas of practice. And so from the survey we did last week, we found out that those who do immigration, arbitration, they are not affected. Very little is affected of their work. And those who have diversified their client base as well, because they are focusing on other markets rather than just Kenyan clients, because a lot of work is still going on in the EU and in the US. People are working remotely, but they're actually still making money. So I think we could consider diversifying our client portfolio, but then also diversify our areas of practice in that particular sense. And I get your comments. Thank you for that, Maria. So I'd want to go to Commissioner Macharia Njeru, who's going to talk to us a little bit about judiciary, what the judiciary is doing. How can the judiciary innovate around this particular pandemic? And there have been, concerns around the technologies that the judiciary is using, what sort of privacy measures. We also have people who are insisting that the courts need to be physically opened. Is it time to reopen the courts? What do we do?
Okay, thank you so much, Linda. Now, of course, it has been challenging for everybody, as all the other panelists have said. But I also look at it in terms of an opportunity on the part of all of us being able to use technology in leveraging when it comes to rendering the services from whichever place that I receive. Now, you recall that when I was contesting for this position of the male representative, LSK male representative to the JSC, one of the mantras that I kept, harping on was the issue of leveraging on technology. Because I felt that unless judiciary, for intents and purpose, is able to become, automated, fully automated, we'll continue losing on opportunities. And it has happened elsewhere anyway. The other jurisdictions, particularly Singapore, which have been able to use automation to an extent that a lot of matters are argued virtually without necessarily making a physical appearance in court. And now, last time when the government, when the executive reduced the budget of the judiciary, one of the areas that was affected was ICT. And at that point in time, we as JSC, and I was part of that team, we took measures of going to Parliament and speaking to them directly regarding the issue of automation. And fortunately, in that supplementary budget, we're able to have that line budget, the line item relating to automation reinstated, and the monies were not interfered with. And that has come in handy in terms of what we're seeing the judiciary has been able to achieve in this time of COVID-19. In fact, I started to think if that money had completely been taken away as previously intended by the executive, would have been in a lot of problems. So judiciary, by and large, has been able to use ICT. We want it to be where it is.
Yeah.
You may wish to know that there is an ICT committee, both at the JSC level, which I'm part of and which I also chair, and also at the part of the judiciary. They also have their own ICT committee, and both are working together in terms of making sure that we fully automate. Now, in the budget that for 2020-2021, what we've also done as the JSC level is that in our meeting, we've decided to reallocate the monies, and primarily to ensure that, again, automation is given a significant amount of money, which means that what we've done is to take away budget from other items of the judiciary and making sure that we allocate those monies primarily to automation. So you'll see a lot of activities, not only during this time of COVID-19, but also beyond, where we'll ensure that never again should the judiciary be caught in a situation where it's not prepared. And so that even beyond this pandemic, we will be able to ensure that as much as possible, practice will continue being ICT driven. But having said that, we accept that there are challenges right now. The opinion is divided amongst lawyers as to whether there should be total resumption of court services or not. And I see this a division, a very big division. The position we've taken, and that's the approval that we gave in our recent meeting at the JSC, is to have reopen, but ensuring that the health guidelines are strictly adhered to. That means that the Ministry of Health also being involved as part, in that process. But at the same time, to also ensure that whatever can be done virtually continues being done, so that there's a mix of two. Now, we have to remember that when it comes to civil practice, a lot of it is by way of submissions anyway. A lot of applications in Supreme Court, by and large, applications are by way of submissions and highlighting. So it is still possible for people to file those submissions virtually, be able to be given time to highlight the submissions.
Yeah.
That can happen either virtually, and if it has to involve physical appearances in courts, it is possible to maintain social distance to ensure that only the advocates are appearing with the parties. Okay. Of course, a party is unrepresented and can come in to be physically there in court at any given time. And to ensure that there is only a small number of people. Sorry?
Okay.
So it is possible to ensure that you have a small number of people.
Some sort of issues. If you could just fix that.
Yeah.
Okay. Silas had a question for Commissioner. If you could.
Yeah, Commissioner. Are you there, Commissioner?
Yes, I'm there.
Okay. Yeah, and I'm really glad that you have mentioned about some of the initiatives that the judiciary has taken so far. As you can see through the NCAJ, the Chief Justice also issued different statements as the NCAJ, and also through Gazette Notice 3137, which gives the practice directions. We can see from all these statements that the court user committee is becoming a very critical part in terms of creating these procedures in different court stations. And you had mentioned about the challenge of budget allocations. Perhaps are there any thoughts that you have had regarding that?
Yeah. As a matter of fact, it is possible, as we speak now, for the courts to be able to operate in a manner that is satisfactory to the various stakeholders at in different stations. The reason why the court users committees are critical is because we cannot be able to say that what happens in Nairobi can be replicated, say, somewhere like Eldoret, also replicated somewhere like Kakamega, or even in other smaller stations. And that is why it is important that there is the involvement, there is engagement of all the stakeholders. And we are very clear also at the JSC that whatever measures are to be taken, let each and every station using the court users committees be able to tailor-make the solutions that would apply in that particular station. And the judiciary will be able to facilitate on its part, because I don't think it's anymore the issue of funding, because whatever funding that is available, it can still be able to ensure that there's success in respect to realize access to justice. Because what we want to ensure is that the courts are readily available for all the stakeholders as and when they require them. We do not want it to be a situation whereby that it's the judiciary that is becoming an impediment. Okay. So as far as we are concerned at the JSC, we've been able to open those tabs. That's why I say that even the resources that are available as we speak, we've picked them from other departments and ensure that ICT and anything that relates to COVID-19 is being given a priority. So it's not a question of funding. It's a question of making sure what is it that you can be able to do at this point in time that ensures that the health of all is protected. All the stakeholders, not only the judicial staff, judicial officers, but also the lawyers and the other parties who are accessing justice.
And what would you say to the senior advocates who wrote to the Chief Justice, indicating that, they do not support the physical reopening of the courts, and that their physical, health would be at risk in going to the courts? We know the statistics around COVID-19 and who is most at risk if they get infected. What assurance would you give them in this case? And
I think for me, we have to listen to everybody, because we are one legal profession. We do not want it to be seniors versus the juniors. We are one profession. Now, the reality that we have to face is that, of course, majority of us who are senior, because I'm also fairly senior, I've now practiced for 29 years. We may not be as financially disadvantaged as our junior colleagues. But I always remember that I was junior at one time and had a lot of financial challenges. And so when I'm looking at how do we ensure that the courts are able to operate, I'm not looking at it from my personal point of view. I'm looking at it holistically in terms of how do you ensure that largely majority of us are satisfied, and not particularly the ones who are most vulnerable. Because I feel, in fact, a lot of times when I see level, I try as much as possible to wear the glasses of the junior lawyers, because let's not be affected. There are many of them who are not even able to be guaranteed of the next meal because have salaries being cut. It is them again who are affected, which is why I said for my law firm, I'm trying to make us, to make it, to make all efforts I can to ensure that they don't have the salary cuts and they don't miss on their salaries. But not many of us can be able to achieve that. Because again, the businesses have to be operational because employers are also affected. So it's a question of how we strike a balance, because to me, we must ensure that courts are able to operate as much as possible, of course, ensuring that the health guidelines are adhered to, but in a manner that most of our colleagues in the profession, particularly the younger lawyers, are able to earn a livelihood. If we don't do that, we'll also be failing them. And it is for that reason that I'm saying that, yes, we listen to everybody, but we must ensure that somewhat, courts are able to operate. And that means that also having some bit of physical attendances, in as much as we are going to have the virtual operations, but we can't totally say that we can avoid physical attendances. And it is possible to achieve it, because you see, if we can ensure that there's social distancing in the courts, if we can ensure that at any given time that the hand sanitizers, that, because the judiciary has the capacity to make provisions. And I can tell you, there is a lot of purchasing that is going on now on the part of the judiciary to ensure that when it comes to hand sanitizing, to ensure that the cleaning of the courts, that, the fumigation, whatever it is that needs to be done to make the courts as safe as possible, that's already happening. The masks are being bought in large quantities for the staff, the hand gloves. So there are many steps that operationally, from the judiciary perspective, it's able to use its resources to ensure that at least reasonable measures can be taken, so that at least the courts can be able to operate.
Okay, I think thank you so much, Commissioner. At the end of the discussion, I think we'll ask really about, is there a way that we could have more testing within the court premises that maybe would, give the assurance that those who are coming in actually not, infected or exhibiting symptoms of COVID-19, and also two, that, there's a particular way that you could sieve out older, judicial officers that they are not obligated to show up in court. I think that will be incredible, and we'll be happy to hear any tools that are, the judiciary is using, because we know a lot of these tools are actually vendor driven, where vendors actually just want to sell or give technologies to government so that they are able to, get data or be able to, do different things, which actually sometimes, most of the time, are not in public interest. So we'll be, looking forward to hear from that during the Q&A. My colleague Silas is going to just take over in the next few minutes, but I want to thank you all who've joined us. If you're joining, this is an event by the International Commission for Jurists Kenya. We have Commissioner Macharia Njeru from JSC. We have Mariam Beneka, who's a council member of the Commonwealth Lawyers Association. We have Patrick Ngunjiri, who is the vice chair of ICJ. And we also have Christine, who is joining us from Katiba Institute, the executive director at Katiba Institute. If you have questions and you're asking on Zoom, please just go to the Q&A section and ask a question there. Or on the chat group. I'd urge the panelists to just keep looking at the questions so that when we do our final remarks, you'll be responding to the questions that have been asked as we make our comments. But at this stage, I'd want to, have Silas, from ICJ make a few comments.
Thank you so much, Linda. As we go, maybe as we finalize on this session and going into the Q&A, perhaps I would ask the panelists to think of some of the five issues within the area that you have addressed. What are some of the takeaways that you can give us, so that when we go, we can, as I said, engage in policy reform and lobbying to the relevant authorities. Just to open up conversation and to give Patrick Ngunjiri the opportunity. Patrick, are you there with me?
Yes,
yes, I am.
Great. You remember, I know you must remember that, you remember Justice Kuloba's statement in one of his judgments that lawyers are not merely unscrupulous, but they are triple satanic. At the end of the day, as lawyers, the fact is our mandate as lawyers is not merely vocational, but it's that of a public trust, and that we have a responsibility to the public to give back to the public, and that the public, especially the vulnerable people in society. So maybe you can expound and give us your thoughts about what can do so that we can ensure that the vulnerable people in society are protected. Yeah.
Thank you very much. Thank you very much. I think when it comes to the role of lawyers in helping the vulnerable people to access justice, there's a lot that we can do. Within the justice sector value chain, we have lawyers in almost all sectors. We have lawyers in practice, we have lawyers at the office of the ODPP, we have lawyers who are administrators, and also we have lawyers who are magistrates and judges, because before you become a judicial officer, first and foremost, you have to be a lawyer. So talking about vulnerability, we have to define vulnerability within the parameters of COVID-19. And doctors have told us very, very clearly that the most vulnerable groups of people around this time of COVID are the elderly and are also those who are living with pre-existing conditions. And these are the people that you have to take care of and have special interest in protecting their lives. We are particularly concerned, or as lawyers, we would be particularly concerned with those among the vulnerable groups that are already incarcerated in police cells, in our remand homes, and also in prisons. Because as a nation, what we have to do, even before we think about access to justice, we need to guarantee their rights to life. We need to have these people alive so that to prevent, by all means, the spread of coronavirus in our police cells, in our remand homes, and in our prisons. So the Ministry of Interior, and I'm talking about the Commissioner General of Police, I'm talking about the Commissioner General of Prisons, that they have to take severe measures to protect the vulnerable people who are within their precincts. And they do so by following the Ministry of Health guidelines, sanitizing, adequate water, social distancing, provision of free masks to all these inmates who are presently in the cells. But
okay, we can hear you.
How do you already maintain social distances in prisons that are already crowded? Because even before COVID-19 struck, our prisons were congested. In a visit that was done by the Senate Affairs for Legal Committee in March 2019, the committee was shocked to find out that the capacity of industrial area prison was 118%. So you just figure that out. We are already congested, prisons holding over and above capacity, and there is an outbreak of coronavirus within those prisons. So we are looking at as a ticking time bomb. And I think it will be the opportune time that ICJ Kenya would call upon the Minister of Interior, the Minister of Interior, Dr. Fred Matiang'i, as well as persons in charge of the police and the prisons, to make public to Kenyans, because we are entitled as Kenyans under Article 35 of the Constitution to know what measures are specifically being put in place to protect the vulnerable by effecting social distancing measures within our prisons. And that's an area that is a ticking time bomb, as I have said. And in the event that we don't have, these measures are not taken into consideration, then we are going to have a catastrophe in our prisons. But I think the solution here is to decongest, and decongest. I must say tribute to our judges, because the High Court judges have taken lead in this. And in the last 1 month, they have actually revised very many prison sentences. They have set petty offenders free, and that way they have decongested the prisons. Number two, we have not had much from the Advisory Committee on the Power of Mercy. This is the time, this committee is established by Article 133 of the Constitution and also relevant statute, I think the Power of Mercy Act. And I think it is time that Kenyans need to hear more that this committee is working more and more. They need to visit the prisons, make it aware that their prisoners, especially the vulnerable, the elderly, are entitled to make petitions to this committee. The committee would then sit down, analyze all the petitions, and in the appropriate cases, it will be prudent to have the committee to advise the president on exercise of his power of mercy. This is another way that this is another mechanism that our constitution and the law provides to ensure that we also decongest the prisons. Once the court reopens, or even if they are upscaling or downscaling, in whichever way, I think Commissioner has mentioned very well that there has to be a modicum of operation of the courts after listening to all the views from the magistrates and judges and also senior counsels. These courts must operate in some form. There has to be some form of a method in which they operate. I'm talking about the diversion policy. And the custodian or the movers of the diversion policy is the office of the ODPP. This is the time that the ODPP, working in conjunction with the probation officers, working in conjunction with the lawyers, has to implement the diversion policy. In this policy, we'll have very many criminal cases being concluded by way of compensation, restitution, expedited hearing, forgiveness, apologies, and just to make sure that that petty offenders are not languishing in our prisons and becoming susceptible to getting COVID-19. Even as even as the courts proceed with their business, I think it's time for them to relax bail terms so that majority of our people, especially those who are poor, those who are vulnerable, will be able to afford the bail terms, conduct hearings where appropriate by technology. And we have seen this happen after NCAJ gave its directions. And also when sentencing, they should consider non-custodial sentences where these vulnerable people will not be incarcerated in prisons that are already dangerous. So NCAJ also, and the Honorable Chief Justice, they must give us practical directions in respect to the hearing of criminal matters. Yes, they have given directions yes, you have some direction from NCAJ, but for them to have normative effect, it will be very prudent at this point in time that we formulate practical directions to deal with criminal matters, to deal with the children matters, and also to deal with anti-corruption cases. So if we take these measures, especially, we would now protect those people who are vulnerable and they're in prisons. Court users are not just the accused persons or the lawyers or magistrates and judges. We also have witnesses. So in circumstances where we have elderly witnesses, sickly witnesses, do we have to proceed with this case so that it is also incumbent upon judicial officers, especially where these vulnerable accused persons are out on bail, to continue adjourning their matters up to a point where this virus is under control. And where we have witnesses that are elderly, witnesses that are sickly, they are susceptible to having coronavirus, I think it would be prudent that we don't make them travel and come to court, and also to ensure that we keep them safe. Let me also, in conclusion, mention a matter that Christine alluded to, and this is about quarantine. I think every second year student in a school of law will tell you that every sentence in law must be provided for, must be specified and provided for in a certain law. I heard the CAS, Dr. Mwangagi the other day, allude to the fact that once you are caught, whether you are going out during curfew time to look for medicine or for a justifiable cause, then the punishment that you have to be handed onto you is quarantine for 14 days. I think the government must understand that quarantine is not punishment. It is a public health measure meant to protect or to curb the spread of coronavirus, so that it is actually unlawful to quarantine people merely because you are out there in a curfew. And therefore, this calls upon for us to have, or the Ministry of Health or the powers that be, to have a mechanism by way of a tribunal where we are able to look at these complaints as they arise. If somebody was genuinely out, then that person needs not to go for quarantine. So we have to have institutionalized complaint measures that are already in place to enable our citizens, especially those who are innocently going out and for a justifiable cause, they are not punished. And so that you also do not weaponize the quarantine.
Okay.
Another important matter that I would want to allude
Patrick, I'm going to cut you short just because of time.
Yes, yes.
Yeah, just a last statement, and then we'll go to the Q&A.
Okay. I just wanted to mention a matter that is very dear to ICJ over the years. We have worked on access to justice for many years. And we are finding a lot of money that is being channeled towards fighting COVID-19. Money from World Bank, money from private sector, money from central bank, running into billions. I think what we want to know is what is the mechanisms that are available from government so that there's openness in expenditure of this money. Christine mentioned about tendering. Who is winning these tenders? Is it in the public domain? So that at the end of the day, we do not have, at the end of this coronavirus thing, we don't have a corona gate. And the way to do it is to avail as much information to our people, to Kenyans as possible on the expenditure. We must also have a very precise designed criteria on who is going to benefit from government's help. Yesterday, the Minister Omalo was on Citizen TV, and he was at pains to respond and to answer Kenyans who is benefiting from the cash handouts, cash benefits from government. There's no criteria. We need to know this criteria as who qualifies for this particular assistance from government.
Okay.
Thank you.
Thanks so much, Patrick. We appreciate that. I think that was very well answered. If you have any questions, we were taking questions you can comment on YouTube if you're watching live, and thanks to everyone who's watching us live on YouTube. We also have on the chat, if you could, ask a question. So I think our panel, you could just go through the chat like I had mentioned to see if there are any questions that you want to, to address. But I'll first just have a few people who have wanted to ask a question. Silas, do you have any comment as we go to the questions?
Perhaps just a quick comment. Thank you so much, Patrick, for that. Maybe as you address the Q&A to Patrick and maybe any other panelists, we have seen a video of one of the gentlemen who said that was a driver who went down to, I think, was it Kakamega, and that he was put on forced quarantine. And we are aware that a lot of people who have been put on forced quarantine have been forced to pay for the bills. Perhaps in your thoughts, panelists, as you address the Q&A, who should bear the cost of these hotel bills and the forced quarantine? Some of them have been quarantined just next to their home. They can't even receive food. We've seen that on social media. So just a highlight as we go into the Q&A.
Okay, I'll allow Millicent to ask a question. If you're ready, Millicent.
Yes,
we'll
I'm ready.
Yeah, so we'll start from Millicent.
Good afternoon. Thank you for this opportunity. My question is that we have seen all these practice directions being given, especially in civil cases. Myself, I'm a prosecutor with the Office of the Director of Public Prosecutions. In the last 1 month, we have been able to conduct some matters using Skype and Zoom. We have taken pleas, we have done sentences, we have also done judgments, but now the challenge is, how then do we ensure that at least, because when we talk about access to justice, it doesn't end at taking pleas, for example, for those people who have been arrested. After you've taken pleas, how then can we scale it up to, you know, ensure some minimum continuity of the trial process? Because once we have taken pleas, you know, we are stuck at that, especially for now. And it seems like, you know, the problem of COVID-19 is not going to end anytime soon. So how do we then ensure that at least we can have some hearings going on, whether, you know, online or otherwise, especially to, you know, in a bid to scale up things so that we do not just, you know, take pleas and wait forever, especially, you know, even if we are giving bails and the bails can be affordable to these people, yeah, you know, the fact that you're facing a criminal charge over your head is really, it's not a good place to be, so that we can ensure some form of continuity.
Okay. Thank you so much, Millicent Odur. We appreciate. I'm going to ask Daniel. Daniel has a question. Okay. Daniel, can you hear us? Okay. Okay, we'll go to Washuka. Washuka Kihenjo, you have a question.
Yes, my question is directed to Christine, especially in regard to the balancing of human rights. We've seen her talking about the restriction of the right to movement and the right to liberty. However, there's the right to health of the public in general that is being put at risk by people who won't follow the government directives, hence necessitating putting them into forced quarantine. So how do we find the balance between these two rights? Is there one right that should be above the other? Because we've seen most human rights agency talking about the individual's right to freedom and movement and all that. Then there's also the issue that we've seen also the public coming up and ganging against the law enforcement agencies, and we've not seen like human rights protection agencies talk about this. So what do they have to say about that?
Okay,
yeah.
Thanks, Washuka. So I'll take the final question from Mokua Manyara. Okay, you can speak, we can hear you. Mokua, can you hear us? Okay. All right then. So I think we'll go into the panel. You could, you know, answer the questions that have been asked on the chat, as well as the questions that we have been, you know, asked on the two questions by, you know, Washuka, and we also have another question by Millicent. Okay, we'll go first. Maria, you want to go first?
Yeah. Thanks. Thanks, Linda. From the questions I've been able to pick a few, and the first one was by Geddy, and he was asking about the possibility of online CPDs by LSK and improving e-filing of the judiciary. I think Macharia will assist me on the e-filing part, but I can just say a bit about the CPDs, having been a council member of the LSK, is that I believe there's already something in the pipeline by LSK, but this should be fast-tracked considering that many members still want to undertake their CPDs, especially those who paid for their PCs. And going by the webinars that we're having very good attendances. This is also a good revenue source for the society. It should not take that much longer for it to be rolled out. Improving e-filing of the judiciary, I'd say that members need to appraise themselves of the CJ's practice rules. The judiciary has done quite a bit of groundwork in terms of preparing for the e-filing. I think the only outstanding issue is the rolling out across the board. But in terms of the basics, those have been done, and it's good. Perhaps the judiciary can partner with the LSK to sensitize members about the actual practice directions and what law firms need to do to register for with accounts with the judiciary, and the courts that are fully doing the digitization. I've seen a comment by a colleague here in the chat saying that most of the courts have upscaled except for the Court of Appeal and the Supreme Court, and I believe our rep can take that up. Jacqueline Waihenya is asking about IT professionals and the credibility. My comment would be that the society has an opportunity to call for a submission or expression of interest by IT providers. They can vet them given basic requirements, basic minimum, so that we know who these are, because you have many briefcase companies that would actually disappoint. So the ICT IP committee can provide basic parameters and terms of criteria that the LSK can use. Members can access this information from the website and pick a service provider of their choice. Jackie also asked about cybersecurity concerns, and the basics are that anyone who is online, whether you're on your computer or on your phone, you must have an antivirus. And this is really important for anyone who's online. The hackers use your webcams. So places like Zoom have been hacked before, and I think they've now improved their security features. If you're using your webcam for Google Hangouts, for your video calls, your chats, and for Zoom meetings, you should basically have a waiting room feature. You should have passwords sent to the individuals who are joining the meetings, and not just open meetings. Hackers are also using phishing emails. These are emails that are sent to you telling you that they have certain offers, and if you respond, then they have access. They gain access, especially if you don't have an antivirus. They gain access to your emails, they gain access to your passwords, they can then gain access to your accounts. This has happened to some of my clients where they have had interactions between themselves and their own clients, and they've sent their bank details that ended up in the wrong hands, and their accounts were cleaned out. So don't respond to the phishing emails. If it's an email address that you don't know before, you're best placed to just delete it or not respond at all until you can confirm from your client or whoever is communicating with you. Get a work email that is not, the usual. I don't want to name names of websites, but get a credible email address for your work, especially, so that then you're only dealing with your clients and not, not just every Tom, Dick, and Harry. And make sure you have anti-spy software. You also have, you don't leave your passwords on websites and things like that. Then there's another question from Azmina about registries, other registries opening, in as much as we're talking about the courts, and this addresses the people who don't ordinarily practice in court. And I am of the view that it is about time that we got, registries such as the lands registry, especially, to really open up and roll out using digital platforms. Just the way BRS have done it before. You've had other agencies such as KIPI who are also continuing with their filings. Those who are doing IP are continuing to file their documents and to do their searches. So it's not impossible. If the police can give you your good conduct online, I don't see why the lands registry should really be dragging so much. Ronald Rogo has asked about post-COVID, new areas of practice. I would say data protection, tech law, IP is still a very huge area. Copyrights and things like trademarks. Tax law is still not as exploited. Medical legal, public interest litigation is a huge area that advocates should take up, because even if you're looking at some of the human rights abuses or the concerns that are coming now with this pandemic, there are many, many areas of public interest litigation that we should actually be following up on. And finally, digitization. That's Akira Jackson, who's asked about lawyers have been fighting digitization of the lands registry. And I thought I should just correct that misconception. Actually, the LSK through the conveyancing committee that is led by Peter Mwangi has done a lot of work through the ease of doing business team. And I remember as the ICT IP committee, we were called in to give our feedback on where we thought the gaps were and making it easier for us to access the work. It is also a misconception that generally that lawyers are not, we are the ones who add up to the cost of doing business. And we've seen this across the board. You saw it with the registration of companies, and that's how we found ourselves locked out of the process. What I want to say to the government of Kenya is this: lawyers, like any other professional, are interested in efficiency. We are interested in livelihoods and making sure that the processes are as smooth as possible. What government should be doing is facilitating every part or every player to ensure that the process is smooth. Then ensure that all these processes take into account our different roles. Because if you lock out lawyers, for example, from the conveyancing process, what you end up doing is postponing the problem, because most of these transactions end back in court because either searches were not proper, or the whether land control boards, which is still a very contentious issue, whether or not, and I think that's been taken out from some communication I saw. What was the mischief that was intended to be cured by having an LCB, for example? So in as much as we want to automate, we must be aware of the risks that our clients and members of the public can fall prey to. And that's why legal services are important. And they must be mainstreamed in those processes.
Okay. Thank you very much, Maria. I'm just gonna say, first of all, Duncan Ondimu says your home office is really beautiful. So I hope it's not the virtual background on YouTube, on Zoom, but no, that's it. And thanks for everyone else who's joining us. Isaac Okero, the former president of the Law Society as well, is joining us as well. So if I didn't mention your name, please don't be angry, but I just got to see those particular messages. So I want to thank you for joining us. We're just going to go to Commissioner Macharia Njeru. There are questions that have been asked around the judiciary. I hope you can, answer them. But then also, it's important for us to, talk about if this persists, and gets worse. What happens? What happens if we close down the courts and have to go remotely? Is the judiciary ready for this? Okay, and Silas has a question as well.
Perhaps just to also add on Linda's question. I mean, we can see across the world, judges and magistrates embracing technology in different interesting ways. You can see, like, for example, Judge Peram in Australia, in a case between Capis and Ford company, embracing technology in very interesting ways and defending it very fiercely, saying that there are all these concerns about security, but yes, these are technologies that lawyers have been using and that judges have been using even behind the scenes. So just to hear from you, Commissioner, as you wind up and answer Linda's and some of the Q&As, maybe just to shed light on that. Thank you.
Okay, and so I think, Commissioner, I'll have you answer that question. There's been something trending this week on social media. There's a judge, I think, in the US who, he spoke to some of the lawyers who appeared before him, and he said that lawyers need to dress up, even for Zoom hearings. Yes. So some of us are putting on coats on top, and then at the bottom there's nothing, and maybe rubber shoes like I'm wearing. So are there like is there a particular way we need to appear before the judges, even if we are appearing remotely? So you can answer, I think, all this. Okay.
Okay. I can take the questions now.
Yes.
Okay. Now let me speak particularly to the issue of if the courts were to totally go remote, to work remotely, whether they are ready. Now, we must be alive to the fact that not all the stations can reasonably say that they are ready. There's a significant number of stations, particularly the ones that are in urban areas, that can manage to do that. I have my serious doubts as to the ability of all the stations to do that, particularly in far-flung areas. The reason why I say this, let's remember that the issue of internet connectivity, which is not uniform all over the country, the issue of availability of power and also the backup. There are many other issues around it. So we are not there yet. But if you're talking about stations here, like for instance, Nairobi, Mombasa, and Nakuru, and others, it is possible to do that. Of course, again, we can't say that because let's remember that this COVID-19 came in not only in a very unprecedented manner.
We're losing you a bit.
But expected it. So it's
okay.
Hello? Can you hear me?
There's a problem with your internet. Maybe I don't know.
Are you able to hear me?
Yeah.
You can hear me now?
Yes, we can.
Okay. So I was saying that COVID-19 came a little bit too fast. So we can't say that judiciary, which has lagged behind it, because we must accept that judiciary by and large had been left behind when it comes to automation. But there are serious attempts now that have been made, and this progress that has been made. So the larger stations will be able to do that. But I would not say the same of the smaller stations, particularly where there's the issue of internet connectivity, the issue of power, etc. So there's a lot of work to be done around that. But as we speak now, I do not think that we face an immediate danger of a total shutdown, unless, of course, something drastically changes. So to me, it's more of a lesson learned that we should be able now to realize that the issue of automation is a key priority, which is why I said that from the JSC perspective, when we were approving the budget that released now to the judiciary, we were able to pick resources from other budget lines and reallocate that, giving priority now to the issue of automation. So you should be able to see a lot of progress regarding that going forward, even as we are working with our current situation. And that is a key priority. And so to me, what I would say is that also the law firms must be equally prepared. So that, because we must also accept that there has been challenges where judiciary is able to render the service, but the lawyers themselves are not ready. There has been some law firms that have been asked for details, they are not able to avail them, or they do not have the capacity on their side. So the two must go together. But by and large, I'm quite confident that as we move forward, judiciary should be better prepared than it is now, but it is still able to render services even with the current capacity that it has. The issues of security, of course, that is quite critical for the judiciary. I don't want to speak so much into that, but that is something that, of course, is being looked into in terms of ensuring that as the services are being rendered, that again, there's no possibility of hacking or information that is otherwise supposed to be confidential gets out there to the public. I believe that is an area that is being given a key priority.
And maybe
e-filing is already happening.
What's confidential about, there's been questions around, if you're talking about security and privacy for judiciaries, what's private other than family matters, for example? What else is private? Can't we open up the courts, even if it's remote, to still have people who are watching briefs, people who are conducting research and things like that, still join in with the courts going online? What are your thoughts?
You see, the thing is that we are not just talking about judiciary and the stakeholders, the members of the public or the lawyers and all that. Remember, there's also the internal communications within the judiciary that must continue happening. And sometimes whatever is happening, if operational matters that relate to the judiciary itself are really open to the public. So there has to be a way that the judiciary can be able to also run its operations in a manner that is confidential, guarding also the interest that relates now to the judiciary that would, where the public would also be affected if such matters, become a matter of a public domain. So we shouldn't just be looking at it from the perspective of judiciary and the lawyers. Let's also think about the internal communication, that the internal operations of the judiciary that must largely also be protected. Just the same way, Linda, your own personal operations in your business would need also to be secured. So that's primarily the perspective from which I'm speaking from. Or even communication. You can imagine a situation whereby judges in a panel, before they come up with a decision, they are discussing, and they are discussing it also remotely. You don't want a situation whereby the thoughts that are being exchanged suddenly become a matter of public discourse. So security is a very critical area that has to be looked at, and it can't really be ignored. But now coming to the issue that had been raised about e-filing, as I said, that is an area judiciary has done quite well when it comes to the e-filing. It's already happening, except of course for a good number of stations that are in far-flung areas where I talked about the issues of connectivity. But the much busier stations and larger ones, I don't think that should be a critical area that should worry us. It's already happening, and it will continue, of course, being made even better to make sure that post-COVID, we continue doing it now, even without that challenge, that becomes now the norm. We must realize that all of us, that there is what now we be calling the new normal. The benefits that we get out of automation, we should continue with them, regardless of whether COVID-19 is behind us sooner than later.
Okay. Thank you very much, Commissioner. We appreciate that. I think we'll go to Christine and then wrap up the discussion with Patrick. Yes, Christine, can you hear us? Christine?
Can you hear me, Linda?
Yes, I can. Thank you.
I think I'll start with the question from, or was Hani Mwashuka, I think. On the issue of balancing of rights, the general, right to everybody's health, and then there's the issues to do with the measures that are being in place to contain the spread of COVID-19. I think we can all agree that Kenya historically has had a lot of problems that now are being made even more sharper because of the COVID-19. We've always had problems in delivery of health services in our country. We've always had problems with police brutality. We've had problems with procurement for government services. We've had problems with openness and disclosure of information from the government. We've had issues with wealth disparity, and now, the welfare support services to Kenyans who need it. So that is now becoming quite evident just because of this COVID-19. And of course, those situations will continue to be with us even during this COVID-19 and after. It's now looking at the lessons we learned from this COVID-19 and looking at how then we can now later on make policies and laws to address the issues that will have come up again during this COVID-19. So in the issue of whether you balance between penalizing people who do not adhere to the guidelines so as to protect the general health of everyone, I do agree that we need to learn lessons from other countries that have dealt with similar situations. And I'm talking about epidemics or pandemics like Ebola. And what we learned from those situations is that when you criminalize actions and measures around dealing with epidemics, then there's usually some sort of social backlash by the people. You actually want people's buy-in and people input and voluntary action to deal with pandemics. That's the thing that works as opposed to criminalization of everything. First of all, also because it goes counter to what we've been trying to say here, and that is to decongest the prisons and to reduce people coming into the criminal justice system. So anyway, for me, what is really critical is whatever measures that are coming in, especially in restricting movement and liberty, they have to be clear, very narrow, and offer options for review, so that the police and the Ministry of Health is not the only people who will make certain decisions. A measure of review, whether administratively or at the judiciary, so that people are able to challenge any of those decisions that are reached in terms of their liberty and in terms of their right to movement as may be restricted. And so what we have then is to provide that second layer of review of decisions. So because, for example, we know that you are placed in quarantine because or you are isolated because you exhibit symptoms, you have COVID, or you're exhibiting symptoms of COVID, or you've been in close contact with somebody who has COVID. So just picking up anybody from the street and just immediately taking them to quarantine without any of these factors being a determinant is actually not a reasonable action, I would say. And actually taking them to quarantine is most likely going to, increase their chances of getting COVID. So there needs to be a measure of review and to follow, medical practice in terms of people who are supposed to be quarantined or isolated. So
okay, and Christine, I'm just wondering, sorry to cut you short. We're running a little bit out of time, but I want to ask, is there any possibility that Katiba Institute could, together with ICJ and other partners, is it possible to take up the issue of quarantine and see, the people who are suffering from this, the people who are sending videos from these particular centers that they are in, mandatory quarantine? How do we help? How do we help the story about the musician who was going to buy medicine for his wife? How do we intervene as fast as we can?
Yeah, so actually we are in the process of doing something around this. And so we are trying to formulate a PIL around this issue, and hopefully within this week, we'll be able to do something about that. We are in the process of trying to get witnesses and statements and all that, and it takes a little bit of time, but actually it's something that is being done. But just to add on to also some of the things that I've seen is issues to do with removing as much discretion as possible from the police and providing a second layer of input to the courts. I think also we've spoken a lot about the courts being reopened from tomorrow, but for me, if I'm sending out a staff of Katiba Institute to go and litigate a PIL case tomorrow, I would want to know what is the procedure to be followed from when I leave when I access the gate of the Milimani Law Court to when I go out. It needs to be very clear. Do we all come for case conferencing to be able to be told your case is to be had at 10, 11, 12? It needs to be a little bit clear that were scheduled for hearing tomorrow. Before COVID happened. So we really need to know what's the procedure to follow once I get to the gate of the Milimani Law Courts. I also wanted to talk about issues to do with the access to
I'm going to give you a minute just because we have to wrap up.
Right, so the issue of digitization and access to information. The Access to Information Act had given about 3 years since 2016 for all government processes to be digitized. And if we had done that, then things would have been a little bit better right now. For example, if I send now, because of this restriction of movement, I really do not want to go to send access to information letters to the ministries. What I would send it to the email provided. There's not even an email. All the requests that we've sent out through using their email contacts of the request that's been received and responded to. So yeah, there are those issues that are coming. Even COVID, now we'll have to see how that can be addressed.
Okay. Thanks, Christine, for that. That's Christine Konge from Katiba Institute. So I'm going to have Patrick Ngunjiri, our final panelist, who's going to take up a few questions, and we've run out of time. But I also recognize everyone else who's joined us on YouTube. This is the ICJ event, ICJ Kenya, and we're just talking about the impact of COVID-19 on legal practice and how lawyers can adjust and serve public interest. And so, Patrick, I'm going to just have you answer a few questions from the chat. Sorry, Patrick. Are you okay? Can you hear me?
Hello?
Yes, we can hear you.
You can hear me?
Yes. Okay. So
So
I'll give you 3 minutes.
Not very many questions were directed to me, but I think I would want to end the session by
You're blocking your camera.
Actually challenging law firms to wake up and smell the coffee. Last year, or 2018, I had occasion to attend a meeting of leading law firms in Zanzibar, although mine is not a leading law firm.
And I think what came up in that session was that about 80% to 70% of legal work that is meant for Africa, that is meant for African continent, is actually conducted by lawyers in Western capitals, in Paris, in London, in New York, and such countries. So that it is time that we innovate and we start thinking about new areas of law. You can guess that for every economic activity around the world, there's a lawyer involved in doing this thing or the other. So we need to look at things like e-discovery. E-discovery these days is multi-billion business in the US and in Europe, and as well as Australia. We need to look at legal outsourcing. Law firms have really thrived through legal outsourcing in India, in Philippines, in Singapore, and as long as we keep being entrenched in the traditional practice that we undertake here in Kenya, then even our lifespan as a legal firms is not very. The future is not very promising. Lastly, because we have been talking about access to justice.
Patrick, you're blocking your mic, so we can't hear you.
You can't hear me?
You're blocking. Yeah.
Hello?
Yes, now we can hear you.
You can hear me?
Yes.
Yes.
Hello?
We
Yes,
can hear
Patrick,
you. We can hear you.
Yes.
Yes, you're good. You're okay.
My last point is that in this session, we have been talking about access to justice. Last week, I was reading the State of Judiciary and the Administration of Justice report.
Sorry, Patrick, you're blocking your mic with your hand, so we can't hear you. Don't block your microphone. Okay, yes. Just remove your hand and you're good to go. Now. You can speak now.
Oh, good.
Okay.
All right.
So,
you're okay now? You can speak now?
Is it better?
Yes. Yeah, you can speak now. You're good.
You can hear me now?
Yes.
Okay, sorry. I think I'm also getting technological challenge. I was talking about the state of Judiciary and Administration of Justice report that was released by the Judiciary in 2018-2019. And this report was very categorical that in the reporting year, that is 2018-2019, Judiciary was operating at 55% of its human resource requirements. So that if we expect Judiciary even to come around for us, even around this time of conflict, then it is high time that Parliament and the Executive fully resourced the Judiciary in terms of the funds that they have asked for, and also in terms of the appointment of judges. It is also the high time that we call upon the President to appoint the 41 judges that were forwarded for appointment by the JSC last year. And this will go a long way in providing rights to access to justice to all Kenyans, especially at this difficult time. It is his duty, it is his prerogative, it is his duty under the Constitution to do so, and we are calling upon him to uphold the Constitution and respect the courts and swear these judges as soon as possible. Lastly, lawyers, please, let's take pro bono cases at this point in time. I was reading an article in press yesterday that
Patrick, you have to finish.
Maria. I think last year she visited a prison in Nyahururu town.
Yeah.
And I think she made a finding that why we have overcrowded prisons in Kenya is because people have been convicted because they did not have legal representation before the hearing, before the sentence. So I'm now renewing this call as jurists, as members of ICJ. Please let us take as many pro bono cases now, as many as we can. So I'm being signaled that you're out of time, but I've enjoyed this session. It has been very informative. I look forward to having many more of such in the future. Thank you, Leader and Silas, and all the panelists.
Okay. Thank you so much, Patrick. I'm going to just allow Alan to join us. He's the former, President Emeritus of the Law Society of Kenya. And I'm going to just have him, make a few comments. And if he has a question, he'll do that very fast as we wrap up.
Yeah. Thanks, Linda. Can you hear me?
Yes, we can hear you, Alan.
Yeah, thank you for inviting me. Sorry, I came in late. My main concern has been that we have been going through this with knee-jerk reactions. We don't have a concerted thought of how we can confront the serious problems we are facing at the Lands Office and also in the judiciary. We're getting different practice directions from the judiciary, and we're all left confused. Let me start with the Lands Office. There have been numerous meetings, but we've not had anything from Land saying that they've been in consultation with the MOH to find out how we can reopen and start business as usual. The government is already losing billions of shillings in stamp duty. We are losing a lot of work, and so are our clients. We go to the NTSA, which is supposed to digitize logbooks. They're not being produced. Now, my view is we need to get our act together, get a team, an ad hoc committee that will address all these issues systematically. If we don't do that, our practice is really going to die in the next couple of weeks. And one thing we have to appreciate, this COVID thing is going to be here for a long, long time. It's not going to go away next month. Let's be realistic. We may be with it until next year. So unless we come up with an emergency ad hoc committee dealing with, let's say, the judiciary, another dealing with lands, and coming up with suggestions and ways of bringing it, working remotely and registration of documents, we are really going to see 100% of the law firm shut down in the next 2-3 months. That's all I have to say.
Okay. Thanks, Alan, for that. And thanks for the service to the Law Society. We appreciate. I think the last council as well, there was a lot of interventions on technology, which now we see why we should have even engaged better as a membership and members of the, the ICT committee. So I just want to have, Silas make his closing remarks as well, and we can wrap up this particular discussion. Thanks for joining us. We've had about 200 plus lawyers join us online. Yeah. We also have, I think, about 100 people joined us on YouTube. And I'd want to thank Rene Ngamau on YouTube. Thanks for joining us. Chacha Odera, thank you. Dan Kanundimu. Thanks for everyone who's joined us and those who have asked questions as well. I think this discussion is timely. We're informed that the Chief Justice is just about to address, to do a live press conference at 2 o'clock on, I think, practice directions and what comes next. So I'd urge you to maybe tune in and be able to engage and know what are the next steps for the judiciary. Silas, you have a few comments.
Thank you so much, Linda. I'm very happy. I mean, that's over 300 lawyers across the country that have joined us today. I can see that we have had very good deliberations. I can see Njeri Gasheru saying that this has been quite informative and challenging to me, especially in practice post-COVID. Another Zaina Kombo saying very insightful discussions. COVID-19 has taught us, all of us, that there's an urgent need to embrace technology, even post-COVID-19, and tap into the potential to enhance access to justice. Someone says, I agree with Maria, land registries should be opened, let them embrace digitization. I think this must be Lina Sarapai saying there should be a deeper bar, bench, and CUC engagement to build on ICT gains. So from what we are seeing is that lawyers across the country are saying digitization, digitization, digitization. Okay. There are other very important questions that are being asked by lawyers about security. Someone saying digitization appears to be inevitable. Are there any pointers as to which products to use and which providers are reliable? Someone else is asking what cybersecurity concerns are prevalent, which are systemic, and which are specific. So I think from what comes out of this discussion is that there is need for both the judiciary and related organs like the tribunals, as well as law firms, to embrace technology. Okay. Just to say thank you so much on behalf of the ICJ Kenya Council, ICJ Kenya Secretariat, back, I know I would have said back in the office, but now it's back in our homes. Thank you so much for finding time to join us in this webinar. This is the first webinar we are holding under ICJ Kenya, and I would like to really express my appreciation to the Lawyers Hub for having collaborated with us in such a short time to pull off this webinar. We are hoping that we will come up with a communique that will come up with the recommendations that will be addressed to the relevant authorities so that we can push some of the recommendations that you've given us here on this discussion moving forward. Okay. As we move on, please continue engaging us on Twitter, on Facebook, on our social media pages at ICJ Kenya and at Lawyers Hub Kenya. Okay. I think with those few remarks, just to say that next week, we hope to have another one. I hope that we'll partner with Lawyers Hub or ICJ or Lawyers Hub, or maybe any other organization that will be willing to join. We welcome you. We hope to address other issues, including what law firms actually require, what lawyers actually require moving forward. What are some of the recommendations in terms of software, practice, going to the nitty-gritties of practice? What do you need as a young lawyer? What do you need as a law firm that is already in practice? Yeah. What do you need to change over? Okay. There are other issues that we will also discuss about, especially issues of mental health and lawyers. Okay. Thank you so much.
Thank you so much, Silas. And I hope you enjoyed this. I don't know whether any of my panelists have a parting shot. I will give you exactly 1 minute so that we can finish up right now. I'd also want to, just thank you and say there are questions about what are the solutions, the people asking us, what are the solutions to this? What did you offer solutions? And I want to say there are solutions, yes. We can't exhaust them in 1 hour, but we wanted to just look at, kickstart the conversation and see what are the solutions that we can get, long term. I agree on the cybersecurity issue. There's been, we did a survey and we found that 64% of the lawyers were actually concerned about cybersecurity. And so it means that that's a matter that we all must engage in and look for technologies and tools, as well as policies that will help us to, encourage cybersecurity. So to my panelists, just exactly 1 minute, and then we wrap it up. Maria.
Okay. Great. Way forward, I believe the Law Society is very well positioned through the national office and the branches to quickly use the force of numbers to get very competitive packages and solutions for our members, and especially those members who have not digitized and are willing to do so now. Secondly, look for a partnership with the SACCO, perhaps because I believe the SACCO had come up with a business support package that can now be used at this time. So I would encourage our members to join the SACCO, take advantage of the products that the SACCO is offering, and use it now to expand the business in terms of the technology. Another way forward is that we really must embrace technology across the board. All government services, especially where lawyer services are required, and partner with organizations such as ICJ, Kituo cha Sheria, Kenya National Human Rights Commission, to ensure that we don't have people who are still stuck in the prisons in terms of plea taking, and support our representatives at the judiciary, our representatives at the JSC, to come up with the credible solutions that can be adopted.
Okay, thank you, Maria. I'm going to go to Commissioner Macharia Njeru.
Now, for me, what I can say is that you can rest assured, I can give an assurance to members of the legal profession that we'll continue ably representing your interests and ensuring, at least in terms of your ability to be able to engage with the judiciary and run your practice from wherever you are, is not hindered, notwithstanding the COVID-19. Now, I can assure you that the issue of digitization is one that personally I'll continue taking a lead in, so that post-COVID-19, we're able to take the legal practice to the next level. It's an area that can also ensure that we are not only efficient, but in terms even also of managing our expenses becomes easy. So I rest assured that this a very this key priority that are being looked into in that area. As I said earlier on, that even when we had our budget approval meeting at the JSC level for the judiciary, we took the decision that it was important to reallocate resources to ensure that priority is given to ICT. So prepare yourselves on your side, even as judiciary prepares itself, and I can assure you that this has been a very good learning experience, in as much as COVID-19 is something we would rather not have encountered.
Okay.
God bless you. Let's keep together. Let's maintain one profession. It's in our interest for us to be united. Even as we have diverse opinions, at the end of the day, we are all legal practitioners, and we want to ensure that everybody's interests are taken into consideration. Thank you very much for the invite and the participation in these discussions of today.
Thank you so much, Commissioner. We have Christine, who's going to make a final comment. Sorry, there's some planes flying above us, so it's pretty loud. But Christine, you could go ahead before we finish up with Patrick.
Okay, thank you, Linda. Can you hear me?
Yes, we can.
Hello?
Right, great. So just like Maria and Macharia have said, I think it's true, let's continue engaging with the NCJ, LSK, and JSC to continue offering our suggestions and solutions as this crisis unfolds. Also looking towards other jurisdictions, similar jurisdictions, South Africa, UK, Australia, and others, and how they are dealing with doing litigation and justice sector during this COVID time. Let's continue learning from the other jurisdictions and see how we can tailor-make those solutions to fit our particular circumstances. And as Maria has said, also, I know there are law firms out, not law firms, NGOs, that also do litigation similar to legal practice like Katiba there. And just wanted to mention there are options for those NGOs to be able to get software at subsidized prices, packages at subsidized prices from companies out there, including Microsoft and all of that. And so we can have more opportunities on how they can be able to access subsidized software packages for institutions doing charitable work.
Okay,
and
thanks,
so
Christine.
All right, thank you, Linda.
All right, thank you very much. And we go to Patrick, who is the Vice Chair of ICJ, who will make the closing remarks and a vote of thanks as well. Patrick.
Thank you, Linda. Though I can barely hear what's going on, but we have enjoyed this session. It's a wake-up call to us in ICJ, where we'll be needed to take action, especially in challenging. We have challenging the draconian laws that are coming in because of the COVID-19. ICJ is always ready and willing to take up those briefs. We have worked closely with the Katiba Institute in the past, and I know that even now we will cement and have a more concrete working relationship with Katiba and other like-minded institutions in terms of challenging these draconian laws. So I agree, because I have had challenge with the listening to this last bit of it. I agree with the sentiments, closing sentiments by Maria, by our senior commissioner, Macharia, and Christine. I have nothing else useful to add. Thank you very much.
Okay.
Thank you so much,
Patrick. Thank you so much, Patrick. I think at this particular point, I would just want to say thank you to everyone else, our panelists. Thank you for joining us and for your questions. Thanks to ICJ for putting this together. And I just want to say from the Lawyers Hub, we are happy to collaborate. I think this should be the attitude within the sector. It's a time that, Katiba Institute, Amnesty International, everyone else who's working within the legal profession needs to come up and support the judiciary in the work that they're doing. We need to offer pro bono services. I like the call by Patrick that we need to engage and take up some pro bono cases. I think it's an excellent time to do that. It's not a time to shine alone, but to see how we can all synergize.
Absolutely.
And ensure that people actually get justice. We expand the pie and ensure that people, lawyers in practice, actually see the new opportunities that are available. Those who do not understand technologies, seniors that are struggling to take up tools, tech tools, for example, law firms, small law firms that do not know how to pay their staff. We need to all come together and figure out solutions for this particular, pandemic. At the Lawyers Hub, we are happy and open to collaborations, and we hope that we can get this discussion going.
Thank you so much.
Silas.
Thank you so much. As I said before, thank you so much, Lawyers Hub, and thank you so much to the panelists. Thank you so much to everyone who has been able to join us. Please do not forget to continue this conversation on our social media at ICJ Kenya and at Lawyers Hub Kenya. Please, the questions that you have asked on Zoom, you can copy paste them on our social media. And I would encourage our panelists to attempt to answer all these questions. Also remembering that we'll come up with a communique that we will send out to the relevant authorities, asking them for some of the recommendations that we have given.
Okay.
Thank you so much and have a nice afternoon.
Okay, thank you guys. Thanks for joining us. My name is Linda from the Lawyers Hub. I hope you can join us on social media. So we'll stop the live stream on YouTube, but if you are on the webinar on Zoom, please continue to interact. We'll give you a few 10 to 15 minutes so that we interact and get to know each other on the and network virtually.